Been here about the last 5 years, and I was also a former trademark examining attorney at the U.S. Patent and Trademark Office. My practice covers all facets of trademark prosecution and practice before the U.S. Patent and Trademark Office and virtually every trademark office in the world through a network of foreign associates. Um, I have probably worked with thousands of trademarks over the past 27 years, examining applications, counseling businesses on selecting, registering, using, protecting, managing, and defending their marks, and representing clients before the Trademark Trial and Appeal Board. I also counsel businesses on protecting copyrights and domain names, and I've been very active as a committee member in the International Trademark Association. I enjoy working with businesses of all sizes and managing and growing their portfolios.
Awesome. Great introduction, Alex. So we're just going to go ahead and get right into the questions. So the first question that I have for you is, what is IP and how do we know what my IP consists of?
Sure. So like the name or intellectual property implies, intellectual property is property of the mind. And there's traditionally 4 types of intellectual property. There's trademarks, copyrights, patents, and trade secrets. Trademarks are basically the legal term for brands. It's any word, name, symbol, design, combination thereof that is used to identify a product or service, and it is a right that is specifically tied to a product, a commercial product or service, a business. A copyright is a expression of art, an original work of authorship in a tangible medium. So it's basically, well, traditionally it's the books, texts, the writings, but it's also art, sculptures, 3-dimensional art, 2-dimensional art, performances, live, recorded, photography, and basically almost any original work of art that's in a tangible medium. And the copyrights are actually a right you have as soon as the work is created, but the limitation of that is that the copying has to be exact, virtually exact. In the case of trademarks, the infringement, so to speak, is just a standard of confusion among consumers as to, whether which mark identifies which business. A third type is patents, which everyone's, I'm sure, familiar with. It's basically covering inventions, processes, compositions, designs. It's the strongest type of IP protection and the most difficult and expensive to get. It basically covers an entire product or service or device, and gives you a monopoly in it for about 17 to 20 years. But then that's it. After that, you can't protect it anymore. And you have to tell the whole world, in order to get the patent, you have to tell the whole world exactly how to make or do what you're doing. And then the trade secrets is basically any business secret that is kept secret through agreements, doesn't have any registration scheme. It's just basically tied to the agreement with whoever you're asking to keep secret. Non-disclosure agreements is the classic example. Mm-hmm. And actually, interestingly, the U.S. Patent and Trademark Office has just recently created a little program on its website that helps you identify intellectual property that you might have if you want to forget what I'm telling you. It is basically a bunch of yes or no questions that says, do you do this? Then you have this. If you do that, you do that. And we'll put up a link. We can put up a link on that later.
Awesome. Well, thank you so much for that baseline of information on intellectual property, Alex. So since we're kind of focusing this webinar on the intellectual property, how we manage it best, we're going to kind of go into some questions about infringement and protecting it. So I want to know, how do I know I'm not infringing others?
Sure. Well, the first step, I guess, obviously, is that you want to know that what you are claiming is your intellectual property. Probably I talk a lot about trademarks. I will go to that example because it's very most common, and that's what I work with a lot. You want to know that it's your own, obviously, that you weren't influenced or are taking from somebody else. That's the main thing. But then, of course, that doesn't rule out the possibility that what you created, someone else somewhere else coincidentally created. So then we resort to databases. And of course, the whole point of a registration scheme for these intellectual properties is to create a database of trademarks or copyrights or patents and who owns them. So for instance, the Trademark Office has the U.S. Patent and Trademark Office has a database that lists all the applications and registrations that have been applied for and that are currently pending. And it says the owner, it says what the product or service is tied to it. So there you can do a trademark search on the USPTO database for free on the USPTO website, or there are commercial databases that package the content a little better and have more searching capability. But generally speaking, you would search the Trademark Office to see what is out there, and that's where it's not as straightforward as it seems. That's where we recommend that an attorney is involved, because like I said, the standard for infringement is likelihood of confusion, and that can be more than just an exact copy of the mark or the goods. Related goods and similar marks are involved, and what's considered similar. So for that reason, it's good to have someone who knows how to search a trademark do the trademark search.
Absolutely. Well, that's awesome that the USPTO offers that link that we'll be providing to you guys after this webinar. If you guys want to kind of do a baseline check of what type of intellectual property you have, if there's anything similar out there, but it definitely can get very tedious from what I hear from you guys. So on the flip side, we know kind of what to look for to know if we're not infringing others, but how do we recognize if our IP is being infringed?
Sure. Well, probably the most common things that clients tell us about how they think their intellectual property is infringed, at least in the case of trademarks, is that they'll say, well, I keep getting these calls that, for this other business. It's not me, but it has a similar name or sound, or they say that they're confused about, if this is my business or that, or related to that other business. And that is usually a red flag. I mean, especially because that means that consumers that may be looking for you are going to them, or vice versa, and that can be obviously a financial problem, or create a real loss. And of course, you might see out there something that looks uncannily similar to you, especially more distinctive that your IP is, your mark is. Obviously, the more it's not a coincidence that it looks the same. So probably those two things are the two biggest dead ringers.
Yeah, so definitely if you're being mistaken for someone else, that's
Right.
interesting. A lot of people have that issue, I guess, when it comes to infringement. That's how they'll find out. So is there anything that I can do to prevent IP infringement?
Sure. Well, I mean, obviously the best thing we recommend is, as I mentioned before, there's registers that when you register your mark or a patent, you're basically publicizing to the world in a database that you are the owner. This is a property of yours that you own, and they should copy. And so for trademarks, I mean, even though it costs money to register a mark, it's really worthwhile. It's obviously a lot less money than having to deal with an infringer down the road. So register the trademark. Also mark your intellectual property. There's designated marking schemes, and for copyrights, there's the C in a circle with the name of the owner and then the year that you see. In trademarks, there's a superscripted TM or SM if the mark is not registered. It's just something you claim is your brand. And then once you do get a federal registration, you can do a little circle or a circle, or you can always just asterisk or note somewhere in small print on a label, such and such are trademarks of. And on websites now, of course, it's easy to have that, listed in terms of use or something like that. So, but definitely mark the intellectual property that you're using.
Awesome. All right. So it kind of goes into how to prevent IP and all that stuff. You went into this a little bit, but is there any other reasons? I want to know why I should register my mark.
Well, another reason actually that I didn't mention is not only is it useful to have your mark listed in the trademark office database so people can look at it. But infringers can't be willfully blind and say, oh, I didn't know about it because I didn't look. The law automatically presumes or construes that you're aware of the existence of that mark if it's registered in the U.S. Patent and Trademark Office. And actually that awareness, that notice goes back to even the filing date of the application. So even if your mark is a pending application, it's not yet registered, it may take 3 years to register, that notice to whoever infringes goes back to when that application was filed. So that's a pretty strong, that's a pretty strong legal case for ensuring that people are aware of your IP and won't infringe it.
Awesome. So if I register my work, does this need to be renewed or updated?
Sure. Cynically speaking, as people know, any government right that is conferred, the government usually needs to recoup that cost, and so they do have maintenance requirements for patents, for trademarks. In the case of trademarks, at every 6th anniversary of a registration date, and then every 10th anniversary of the registration date, there's going to be a fee needed to be paid, and what's called a Section 8 Declaration of Continuing Use, which actually not only maintains the trademark registration, like a tax, but it also demonstrates that the mark is still in use, because in the U.S., more than a lot of other countries, the use of a mark is really what confers rights in the mark. And as soon as that mark is not being used, the rights can be lost. So the USPTO wants to see, and in general, our society wants to see that a mark is in use if someone's claiming rights in it.
That makes sense. So we went over the IP infringement, how we can spot that, how we can prevent that, but let's say we are being infringed upon. How can I fight that? What should I do if it's being infringed?
Sure. So obviously everyone was aware of going to court and litigation, but that's really the last resort. The first resort is usually what we call a cease and desist letter or demand letter, based on the language that is usually used in the letter. We demand that you stop using this mark, or we demand that you cease and desist, using or registering the mark. And I mean, there's not a legal procedure or legal significance to that letter, other than the fact that it basically initiates a dialogue that hopefully leads to a settlement before any litigation. Most people do respond. Most people are innocent infringers, so they're going to stop using the mark if they can, especially if you can catch the alleged infringer early on, like as they're adopting the mark, as they've just filed an application. I mean, the more they've invested in the mark, the longer they've gone using it, the more tougher it's going to be, because they're more vested in the mark. They're going to want to, it's going to cost them more to give it up, so they're going to be more willing to defend that mark. So, and then there are, I mean, and usually there are settlements, usually, like I said, with the cease and desist letters, it's usually in the interest of the mark owner to allow a phase out period, because even whatever loss they might suffer from the use of the mark on the other product, it's not going to amount to the cost it would be to litigate.
Okay, so more often than not, you usually send a cease and desist letter, and typically that process looks like there's a phase out kind of portion of when they start changing their branding so that they're not infringing upon you.
Right.
Okay.
And there might,
Okay.
yeah.
Awesome. So then it's very rare that you actually go to court. That's only if they refuse to stop using it and are doing it intentionally.
That's correct. It's very rare, actually. A few cases that you hear about, I mean, you can hear about some pretty prominent ones, and they can get pretty involved, but
it's more rare.
It's more than 9 out of 10 times the case is gonna settle in one way or another.
Yeah. Okay. So is there anything else we should know about cease and desist letters, like when we should send one, how that process actually works?
Yeah. So like I said, it's not a legal procedure. In the US, it's not a legal procedure. It's not a legal proceeding to send a cease and desist letter. There's no set rules on, how to send one, what to say, what time frame, or what happens if you don't, if someone doesn't respond. Of course, there are norms, people usually want to respond within 2 weeks. There's going to usually be a follow-up. Now, there are other things to do with a cease and desist letter. I mean, sometimes people take a position that's not necessarily considered normal or appropriate, and they might be a little over-aggressive, and so you might be able to defend the cease and desist letter basically with an argument back, or you present. There's in the case of trademarks, you can show that a mark is weak because there's a million other marks out there. And then, like I said, there's also the negotiation. One thing I would recommend not doing when you get a cease and desist letter is ignoring it, because the sender's not going to forget about it. I mean, they've worked up some type of effort, expense with a lawyer to send the cease and desist letter. They're not going to just forget about it if there's no response. So, not responding probably is the surest way to get a little litigation, legal action initiated against you.
Okay, so I definitely want to respond if I get a cease and desist letter. That was the next question I was kind of going to ask you, is what do I do if I receive one? Do I need to get attorney help? Is there any particular way I respond to that? How does that go?
We strongly recommend that you would consult an attorney. There's not a requirement to, but obviously attorneys have experience knowing how these things play out. They know what to say or not say. Anything once that process starts where a letter's sent, basically everything and every dialogue, especially if it's going to be written in writing, there's going to be a record of that becomes a part of the evidence of what what is said, and that can be construed one way or another, whether you're innocent or guilty. And so yeah, we would strongly recommend that an attorney both send the letter and respond. Now, a lot of times the client will maybe want to initially send the letter, especially if it's an in-house counsel.
Yeah.
But the recipients usually are going to be more. They're going to be more alert and concerned when an outside counsel or starts to be involved, because then they know that that's that much closer to going to court.
Okay. So we went over cease and desist letters. Now, let's say I do have to go to court. I do need to sue or something like that. I know a lot of times people aren't going to want to do that. There's a lot of time and money that is involved in that. If I don't choose to go that route, will I lose my IP rights?
That's a good question. It's a particularly good question in the case of, let's say you send a cease and desist letter and you don't follow up on it. If you're not willing to go to court and you send it, and then let's say the situation somehow lapses, the defendant still continues to use the mark, the plaintiff, they for whatever reason didn't follow up and isn't suing, then it becomes that much harder down the road to go after that defendant again. I mean, if you go after the defendant, well, I mean, for one, there's doctrines like laches, where if you you can create a prejudice where the defendant begins to rely on the fact that they're allowed to keep using the mark because you didn't stop them. In the classic law school example, for trespass, you can't wait for someone to build a house and then say that they're trespassing, obviously, right? You have to try to stop it as soon as you can. And I mean, in trademarks, it is a common philosophy, I guess, that you can use it. You either use it or lose it. You either enforce your mark or you can lose it. Basically, the way that you lose it is if you don't enforce it and a lot of other people start using the similar term for the same products or services, then that term becomes weak. It's virtually unenforceable. How can you claim, ABC is your mark if ABC is used by almost everybody else in the industry, and the ABC is not going to point uniquely to you if there's so many other users, and that's hard to undo. Then you can't
Yeah.
go to court and say, well, this is my mark and I want to stop all these users because it's already been out there, as sort of a common term for the field.
Interesting. Okay. Yeah, so you definitely want to jump on it and take action
Yes.
right away. Otherwise, it gets a lot more difficult if you don't down the road.
Yeah, so you have to you have to make a decision at some point early on. Are you going to stop people from using this all the time, or are you not? I mean,
Mm-hmm.
if you're not, you have to be prepared. I mean, yeah, there's been cases I remember. I'm trying to remember. Well, I can't think off the top of my head right now, but there have been cases where, like, I think there was a computer company that tried to stop everyone from using this term. It was like the mini computers had a term to it, and it was
Mm-hmm.
Netbook, I think it was called Netbook. The netbooks were like mini computers, and there was actually a company that I guess created that term and that created that term and used it, and then they wanted to consider it their mark, but everyone else started using it to refer to these little computers. And when they wanted to finally sue a bunch of people and say, this is our mark, you can't use it, I don't think they were successful. I don't know if the court said it's generic, but that is how marks become generic.
Mm-hmm. Okay. Yeah. Well, thank you so much for answering all these questions, Alex. I feel like we got a lot of information from it. I want to take this time to open up the floor to the audience members to see if they have any questions that they would like to be answered by you. If you do have a question, you can go ahead and click that button on the Q&A section at the top, or you can chat and submit something in the box, and I'll go ahead and ask Alex that. I'll give you guys a few minutes to just think through if you have any questions, and we can address those. Not seeing any questions yet right now. We'll give it a little bit more time. I see someone raising their hand. Let's see. Christopher, here, I'll allow the mic for you, Chris, if you want to ask a question. Let's see. I think we've got it set up that all the audience members are muted right now. So if you do have a question, you could type it into the chat or type it into the Q&A section. Oh, let's see. How can you establish minimums? Oh, where'd it go? Let's see. We've got a couple questions coming in. So one is, how can you establish minimums in a licensing agreement?
Okay, minimums, I take it, that means either the minimum amount of a product sold by the licensee or the minimum dollar amount. That's actually a contractual term. It's a business term that is, well, license in general is a contract. And that's usually going to be pre-negotiated by the parties. So, I mean, this varies per industry, but I think, basically whatever you think is normal for your industry or whatever you can command based on your market, you would, tell the licensee, I want you to sell this amount. One thing I should mention that could be done. So there's two types of licenses. There's exclusive licenses and non-exclusive licenses. Exclusive license is basically the mark owner and just one licensee. And some other, not even within that, there's a couple different types. There's exclusive licenses where even the mark owner can't use the mark, only the licensee uses the mark. And then there's less exclusive licenses where basically the mark owner and the licensee are using the mark. And then the non-exclusive license means that there's going to be multiple licensees, and I know that in some cases, a lot of if you don't want to set a minimum or you don't know the minimum, you can just basically have a non-exclusive license with a bunch of licensees, and they're going to compete with each other. And then obviously the licensees that can sell more are going to be more favored by the mark owner or get more business.
Okay, so then going forward with licensing, we've got another question about what to look out for if licensing IP. What is reasonable expectation for percentage of profit?
Okay, so I take it then looking out for, and what to look out for in licensing, that's from the perspective of the licensee. I think from the licensee's perspective, well, if a licensee is relying on the license to be able to do their business, to be able to sell a certain product, I think it's going to be in the licensee's interest to have that license continue as long as possible, as reliably as possible. So they're going to want to minimize requirements or make sure the requirements are reasonable. They want to make sure also the product is going to stay a good quality and desirable. That's the manufacturer's job, that the product is going to be, quality product. Obviously no defects and liabilities. There's on both sides, you're going to have liability concerns and insurance issues. Usually there's going to be hold harmlesses on each side. I mean, it obviously gets pretty involved. And again, that's more of a contractual negotiation, and a lot of trademark lawyers do that. We do that, and we have other regular commercial lawyers too as well. So.
Okay, awesome. So there are a couple other questions. I'm going to jump down to one and come back to another. One says, what should a business consider to trademark? Name and logo, would they be done together or separately?
That's a good question, and that can be actually a pretty involved consideration. Ideally, you want to trademark every distinctive element, and I guess we've said there's I've heard attorneys say there's like a Cadillac approach, a Chevy approach, and the middle of the line approach, where basically the more efficient or the less costly way is to just apply for the whole logo, with all the elements, and assuming you're going to use it that way, because however you register a mark, it has to be exactly how it's going to always appear you've been used. So if you register the logo and the wording together, well, you get the benefit of the wording being registered, especially because the law says that wording usually is more dominant and significant than design. So the design element's not going to detract from the wording. But if you can register the design separately and the slogan separately and then the mark separately, then you have each of those that can be asserted separately against someone who's infringing only one part of that. And I say that's the Cadillac approach, the a la carte of the separate applications, because each application you can only have one mark per application. You can't put different variations in the same application. So you might need 3 applications to register the slogan and the logo and
The title.
or the mark itself.
Okay.
Versus one application. Then if we usually the cost is per application with the attorney. So.
Okay. So then another question going back up is from Griffith. He wants to know how important to file a trademark application is versus relying on common law rights.
Good point. Good question. Because in the U.S., you don't need to register a mark. You can actually just you get rights in a mark as soon as you start using the mark in commerce. The thing is, with the common law rights, meaning the unregistered rights, they're limited to the actual market where the products or services are offered and sold, as opposed to the rights being nationwide as soon as the mark is registered. The registration gives people presumptions in court about evidentiary presumptions, which are basically shortcuts. So you don't have to prove your ownership and validity of a mark if it's registered, whereas if you don't have it registered, you do have to prove that. But if it came down to spending money to just clear the mark and search the mark and make sure it's available versus registering the mark, I would say do the search and defer the registration, because you do have the rights, like I said, from just the use that you can enforce. But it's more important to make sure that you're at the outset not infringing on someone else's mark, not accidentally using a mark that's similar, that down the road a business is gonna say all of a sudden, no, you got to stop using this.
Okay, so kind of adding on to that, could you explain at what point upon filing for trademark I can start using as a trademark?
Well, you can start using a mark anytime in relation to filing. You can actually, it used to always be you have to have used the mark in order to file to register the mark. That was the way it was until 1989. In 1989, there was a massive change in the law where now a business could file what's called an intent to use application and basically file to register a mark as much as 3 or 4 years before the mark is actually used. And then so now there's basically two processes for registering a mark. Either the traditional way, you're using the mark from the onset and you're proving use when you file, or you file, you get the substantive examination, and then at some point you present your evidence of use, which could be as late as 3 years after the application is allowed. After it's allowed means the application has been approved by the examiner and it hasn't been opposed. So that's usually a 9-month to 1-year process at least. And then you can, with extensions, you can extend it 3 years.
Okay. All right. So then another question we have is, if we have registered IP in the US, but a foreign entity is selling into the US market using the IP, how do you proceed?
Okay, so the timing here is critical. So if I understand correctly, the business in the US has the mark registered and has been using it, and then the foreign company comes over afterwards.
And they're selling into the US using that IP.
Okay, so trademark rights are territorial, and that basically is in every country. There's no one country that says the registration extends to other countries. So the company from overseas that's coming into the US, they're not going to have rights in the US, even if they have rights in their own country. They're not going to have rights in the US in their mark. So the US mark owner is going to have rights ahead of, or prior rights to that foreign company, and can tell that foreign company to stop using the mark in the US, basically. If it were the other way around, the mark owner hadn't started using the mark yet. If the foreign mark owner they could set up their prior rights in the US by just filing an application, and there's treaties that allow rights to go back to their rights in the foreign country.
Okay. Yeah, interesting. All right, so I think I've caught up on most, if not all, the questions. I see someone typing, so we'll just give it another little bit to see what question they have. All right, it doesn't look like they have a question. They're just saying it's been an excellent webinar, which I completely agree with, Alex. I do see one guest raising their hand still. I don't know if that's just a wave or if they're raising their hand for a question. They can go ahead and type something, or I'll allow the mics. There we go. Yes, Christopher, what's your question?
Yes, my question is a food product, and not only with a food application, but also a side application. Can that be trademark? I'm not sorry. Can that be patented?
Okay, what do you mean side application?
Well, I don't want to give away what the application is, but it would be entertainment.
Oh, okay, so you're talking about two different products, but the same mark. Okay, sure.
No, not a mark, just whether the food product can then be used for also entertainment. and it's a specific shape.
Okay, so, well, there's a few different IP protections there. I mean, in my experience, food can be patented, but you're talking about making a unique composition that has never before been done. And I think with food, that's not common. So usually food is difficult to patent. I believe trade secrets oftentimes are used to protect foods like Coke. If you're talking about a unique process, like if it's if this food product has never been combined as an entertainment feature as well as a food, that concept could probably be patented. The shape of a food product, if it's unique enough, the design patents protect shapes. And there's actually a lot of overlap between design patents and copyrights and trademarks, trade dress. And there are differences. So basically with the patents, you're talking about the rights you're claiming versus the rights that have been out there before. If there's enough difference and novelty, then, that might be protectable. Does that answer your question? I'm not sure if I.
Yes, thank you very much for your time and education.
You're welcome. You're welcome.
Wonderful. So then we'll just take one last question. It looks like we've got one from Michael. How do you register your US registered mark in another country?
Okay. Basically, there's two main ways. I mean, the traditional way that would always exist is that you simply go directly to that country. Usually you go through foreign counsel. Usually you have to go through foreign counsel. I don't think in a lot of countries you're allowed to file yourself. And you basically file for that same mark and same good services in that country. Now, if you're not tied to the US registration, then you probably have more freedom to apply for the mark and whatever goods or services you want to associate with the mark. Now, if you do tie the application in the foreign country to the US mark, which you can do for the Paris Convention in almost any country, then you have to, well, for one, the benefit of that is that you get to claim the priority of the US application. So if it's within 6 months of the filing in the US, you can basically use the US filing date in the foreign country. And in those cases, the marks have to be identical, exactly identical. The goods or services have to be virtually the same or within scope. And then the owners have to be the same. And then there's another way. For a lot of countries, not every country, there's another treaty called the Madrid Protocol. I think there's over 110, 120 countries now a member, but that is a process of extending the home country registration, in this case, a U.S. registration, into another country. And you can do that actually from the U.S. Patent and Trademark Office. Again, assuming it's a U.S. registration, you basically file an application on the USPTO website to an organization called WIPO, the World Intellectual Property Organization, and you can designate any number of countries that are parties to this treaty, and WIPO will send the application to those countries, and effectively you're multiplying your application into multiple applications in different countries, like a cluster that are all being examined at the same time and registered, and that's called an international registration. That's a relatively new development and one form of registration that we can call international.
Awesome. Well, I think that's all the questions for this time. Our meeting's about to end anyway, so we'll just have it wrap up here. I just wanted to take this time to thank everyone so much for joining. We're really glad that you guys were here. And Alex, thank you for doing such a wonderful job in teaching us more about IP and how to best manage it. We'll
You're
definitely
welcome.
send out Yes, we'll send the meeting recording out to you guys afterwards, so you can definitely take a listen to it and watch it again if you have any other things you wanted to readdress or like look at that was discussed in this webinar. Otherwise, if you have any other questions, you can certainly reach out to Alex or anyone here at DBL, and thank you so much.
Right, my bio's on the website. You'll see my email. Feel free to email me. We have handouts sometimes and some other stuff. So glad to help, glad to answer questions.
So thank you, everyone.